Welcome, everyone. My name is Andrew. I'm the founder and owner of Ibis Prep, and today is the last lecture for the July 2025 Florida bar exam, and I'm super excited to go over every single subject. I'm going to start with the essay subjects in order of how they were taught, starting with contracts. My mnemonic for contracts is buy friends drinks, big drinks. B is body of law. F is formation. The D is defenses. The B is breach, and the D is damages. Contract body of law means UCC versus common law. UCC is for goods, which are all things movable, and common law is for land or services. There might be the predominant purpose test if the contract contemplates goods and services, and you'll see which predominates the contract and apply that corresponding law. It's important to determine what type of contract we're dealing with. Is it a unilateral contract, a bilateral contract? Is it an output contract? Is it a requirements contract? Is it a divisible contract? Is it an installment contract? Is it a quasi contract? Or is it an options contract? It's also important to note whether the parties are merchants or whether a party is a minor, if there's any conditions that would allow special rules to apply to the party. For instance, merchants, we consider the firm offer rule, the bow of the forms provision, and other potential rules that would apply to merchants. And if they're a minor, then the contract could be voidable unless it's ratified by the minor upon the age of majority. So once we've discussed the body of law, UCC versus common law, we want to discuss contract formation, offer acceptance, consideration, and no valid defenses. The offer is a outward manifestation of an intent to bind another party to a contract that gives the power of acceptance in the offeree. And acceptance is a meeting of the minds or a mutual assent that creates a contract between the parties. Consideration in Florida is a bargain for exchange of mutual detriment or value. Consider here when we're having the formation, whether it's the mirror image test under common law, where the terms of the acceptance must match the terms of the offer exactly. Consider the firm offer rule between merchants under the UCC, where an additional term, so long as it's not material, will be included in the contract. Although if it's material, it'll be knocked out, and UCC gap fillers will apply. Think about what the essential terms are for a UCC contract. It's the quantity and description of the goods, but not the price. The offer, acceptance, the consideration, these are all going to form contract formation, whether it's bilateral or if it's unilateral, it can be accepted by performance. Then we want to talk about the defenses to contract formation or execution. So remember, formation is, body of law is UCC versus common law. Formation, offer, acceptance, no consideration. Offer, acceptance, and consideration. And then defenses. The main defense is a statute of frauds. Certain contracts must be in writing and signed by the party to be charged. These contracts include contracts in contemplation of marriage, contracts that cannot be completed within 1 year, contracts for land, executorships, and sureties. Exceptions to the statute of frauds are specially manufactured goods, written confirmatory memos, admission in court, promissory estoppel, and performance. Other defenses to contract formation and execution include fraud, duress, misrepresentation, mistakes, which can be mutual or unilateral. Unilateral mistake, the mistaken party will bear the burden of their mistake unless the non-mistaken party knew of the mistaken party's mistake and essentially took advantage of them. And then mutual mistakes, we can either rescind the contract or potentially reform the contract to fulfill the intent of the parties. Other defenses, illegality, illusory contracts, incapacity, infancy, intoxication, unconscionability, procedural and substantive, undue influence, impracticality, impossibility, frustration of purpose, latches, unclean hands, acquiescence. all different defenses to contract formation and execution. The heavily tested ones, statute of frauds, mutual mistakes, unilateral mistakes, and impracticality, impossibility, fraud, duress, misrepresentation. Those are some of the more heavily tested ones. Then we're going to talk about a breach. A breach could be material or immaterial. Material breach will go to the heart of the contract and allow for rescission, or not necessarily rescission, but it'll go to the heart of the contract and allow for damages. Whereas an immaterial breach is minor and will potentially allow for damages, but not complete damages. An anticipatory repudiation is when one party unequivocally demonstrates an intent not to honor the obligations of the contract. Damages in contract law can be legal or equitable. Legal relief or monetary and include expectation, consequential, incidental, restitution. I keep saying reformation. Restitution, reliance, and liquidated damages. Remember, liquidated damages need to be reasonable and cannot operate as a penalty. They're calculated in advance when damages would be too speculative in light of a breach. And then equitable relief would be specific performance, reformation, rescission, promissory estoppel, quasi-contract, injunctive relief, replevin. These are equitable means of remedy, right? So in recap, body of law, formation, defenses, breach, damages. Additional topics you can expect to see would be like a modification, which requires consideration at common law, but only good faith under the UCC. The parole evidence rule, where we're not going to allow extraneous evidence to contradict a fully integrated contract unless it's to show a condition to contract, defect information, to clarify ambiguous terms, to show custom, trade, or usage, but not to conflict the actual terms of the contract. There could be an accord and satisfaction, an agreement to pay off a earlier debt with a new amount. The accord is the agreement, the satisfaction is the payment of that amount. There could be the firm offer rule where merchants can keep an offer open if it's in writing and signed, even without consideration for the stated period or up to 90 days under the UCC. There could be a non-compete agreement where the agreement must be reasonable in geographic scope, in subject matter, and duration. Remember, installment contracts will have the opportunity to cure in the event of a breach in a subsequent installment. Third-party beneficiaries, intended versus incidental beneficiaries. Intended are contemplated and named in the contract and could potentially have rights if they vest to enforce the obligations of the contract, where incidental beneficiaries merely benefit incidentally and cannot stand in the shoes of a contracting party. Those are some of the key pieces to writing a contracts essay. Firm offer rule, battle of the forms provision, mirror image test. Remember, at common law, we need substantial performance, where under the UCC, we have the perfect tender rule. So consider a non-conforming shipment and what the effect would be. Also, the duty to mitigate damages, and when measuring damages, look at the cost of cover, the market price, and other potential claims. Maybe there could be a confirmatory memo that would take it outside of the statute of frauds, or a discussion under the battle of forms provision, whether a term is material and should be included, or immaterial and should be included, or whether it's material and should be knocked out, and if UCC gap filler should apply. In general, I think a contracts essay is super manageable. I think you can all do great on it. Remember, buy friends drinks, big drinks. And if you forget that mnemonic, I'll remind you when you come and see me at American Social Wednesday night after the exam, because I am your friend and I do prefer my drinks big. All right, so for torts, some of the big things to learn are that Florida is a modified partial comparative fault state. That's the same thing. Modified and partial means that if a plaintiff is over 50% at fault, they are barred from recovery. Florida used to be pure comparative fault, which meant that anyone could recover, but now we're modified partial. Florida's also abolished joint and several liability, so you have to recover from each defendant severally. So Florida's abolished joint and several liability. Florida is a modified comparative fault state, and in Florida, punitive damages are limited to 3 times compensatory or $500,000, the greater of the two. Intentional torts, assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion, intentional infliction of emotional distress, intentional interference of a business relationship, tortious interference, intentional misrepresentation, also potentially malicious prosecution, intentional endangerment, any civil act that has intent. And then there's elements of intent to defamation and to the privacy torts. So defamation, it requires malice if it's a public plaintiff, mere negligence if it's a private plaintiff. Libel is published, slander is spoken. Slander per se applies to crimes of moral turpitude, loathsome disease, a woman's chastity, and related to a person's business. The media defendant rule in Florida means that if a media defendant, like a newspaper, defames a person, like a celebrity, and they provide notice within 5 days of the statement, the media defendant has 10 days to retract the statement, and they can only be liable for the actual damages, nothing else. Negligence requires duty, breach, causation, and damages. Causation has to be actual and proximate. Proximate is the foreseeable plaintiff for the zone of danger. Make sure to write about potential intervening or supervening events that could lead to indemnity or contribution. There's negligence per se, statutory negligence. There's res ipsa loquitur, the thing speaks for itself. There's respondeat superior, third party liability, employer employee liability, right? There's non-delegable duties, these types of discussions. Strict liability can apply for inherently dangerous activities, wild animals, and products liability cases. For products liability, there's strict liability theories of design defect and manufacturing defect. There's express warranties, failure to warn, and inadequate warning. And then there's the implied warranties of merchantability and fitness for a particular purpose. Remember, whenever you write about strict liability, products liability, there's a contemporaneous argument for negligence. It was also negligent to design it this way or manufacture it this way. For design defect, you're talking about the risk utility balancing test or the consumer expectation test to determine if it was defectively designed. A design defect is when when a supplier, retailer, producer, distributor, manufacturer, wholesaler, any commercial seller places a defective product in the stream of commerce and injuries result. It can be anyone downstream of the defect, not someone upstream, not a component manufacturer or someone who made a non-defective part that was defectively manufactured. Florida has the dangerous instrumentality doctrine, which means you could be held liable for lending your car or a boat to someone else who causes injury. Be on the lookout for a premise liability case, which would impose different duties based if they were a known trespasser, an unknown trespasser, a licensee, or an invitee. Florida pretty much recognizes licensees as invitees, which is the most heightened duty of to warn and make safe and to do reasonable inspections or sweeps of the property. An unknown trespasser, they're not really owed any duties except not to cause intentional harm, like a spring-loaded trap or attack dogs. Florida's abolished the one bite rule, so you can be held strictly liable for your dog's bite. Privacy torts are intrusion upon seclusion, appropriation or misappropriation, and public disclosure of private facts. Talk about defenses to, intentional torts and negligence, potentially statute of limitations or res judicata or collateral estoppel or maybe consent or contribution or privilege, right? Like you could be privileged to trespass if it's for an emergency or you could even be privileged to defame if it's invited libel in a, letter of recommendation or something like that. Um, and then damages, you can recover compensatory, punitive damages, um, pain and suffering, medical expenses, lost earnings, loss of consortium. These are different damages that can be recovered for tort claims. There's wrongful death and survivorship claims. Wrongful death is for the actual death of the person wrongfully, where survivorship claims are claims that the estate can bring on the deceased behalf that may linger after they've passed. A medical malpractice claim, it requires that the practitioner is given notice and a third party verifies the legitimacy of the claim, and then they're given the opportunity for either mediation or arbitration, and there's a limitation on the damages that can be awarded. So, just start with a duty of care. What was their duty of care? Was it breached? Um, were there damages? And was there causation? Give arguments both sides. IID, NID, like, IID is outrageous conduct, negligence, negligent conduct that leads to emotional distress. You can talk about the zone of danger theory. Florida has relaxed the impact rule for NIED, so there doesn't always need to be a physical impact, especially if it's for like mishandling of a corpse or something that's especially likely to create emotional distress. But my argument for y'all is on torch, throw the kitchen sink at them. Try to discuss as many torts as possible on every essay. So here's an example. I walk outside, someone throws a rock at my head and says, Ibis Prep sucks. What claims of action can I bring? Obviously, assault and battery, right? They put me in apprehension of harmful contact, and then there was harmful contact. The assault and the battery is clear. There's also trespass to land, right? That rock invaded my property. That was an intrusion on my private property by an object they were in control of. There's definitely defamation. They said Ibis Prep sucks. Oh, by the way, I got so much merch that I'm bringing to Tampa, like a crazy order of merch. So if you see me and you want anything, I got it. Magnets, pens, shirts, custodial janitor uniforms, like fucking everything. Binders. I got tons of merch. But the reason that I was talking about that, I can't remember, is in torts, talking about damages, um, and throwing the kitchen sink. Yeah, okay. Oh, I know why I was talking about my merch. Because if they said Ibis Prep sucks, well, that's clearly a lie. We don't suck. We rule, and we're cool. And if I stepped outside and my neighbor said Ibis Prep sucks, well, maybe another neighbor heard. I live in a townhouse, right? That's defamation. In fact, I'm going to argue that's slander per se because it's about my business. I'm also going to argue IID and NIED. Right now, every time I step outside of my door, I'm afraid of a rock coming. I have, now I go to therapy. Now I lost sleep. Right? Why. These are all reasons why I think that we could bring many claims of action when I step outside of my house, they throw a rock at my head and say, Ibis Prep sucks. I'm arguing for assault, battery, trespass to land, defamation, slander per se, IID, and NIED, right? That's 7 claims of action that I made when most people would just do the assault and battery. So that's how I encourage you all to write your torts essays. Throw the kitchen sink at the reader, write as much as possible, and give counter arguments and consider, what duties were owed, if there were intervening or supervening events, and if there's going to be a modified comparative fault discussion or abolishment of joint and several liability. And always remember to discuss damages, right? Pain and suffering, loss of earnings, loss of consortium, these types of things. So torts is my favorite subject. If I took the bar exam, I'd always pray for a torts essay. It's just, who got hurt, how are they wronged, and then what are their claims, and then switch your hat around and be the insurance defense company. I tell you, I have thousands of students now. I've been doing the math. I have thousands of students now who are practicing attorneys that came through my program. The number one job they have is insurance defense. I don't know why or it is, but that's just a really practical thing. So imagine you're one of my hundreds of former students who practices insurance defense law, and what would they argue? They would argue that, they're not liable, they didn't have a duty, or they assumed the risk, or all these different things. So make sure you give the argument that's obvious of why the person got injured, and then make sure you give the argument for why most of you are going to get paid for, which is why their other side is not liable, right? So I think that's the problem that people have is they're so focused on the stronger argument, but the points are also made in the counter arguments. All right, so we got contracts, we got torts. Let's talk about con law. So con law as a federal subject is very similar to the MBE or to everything you've learned in life, right? You got to know the amendments to the Constitution. The First Amendment protects the freedom of speech, freedom of religion, freedom of press, freedom of petition, and freedom of assembly. The freedom of speech is not protected if it's true threats, if it's words likely to incite imminent loss activity, if it's hate speech, if it's obscenity, which are words that appeal to the prurient interests of humankind and are devoid of any artistic or literary value. It's defamation and it's false or misleading commercial speech, right? These types of speech are not protected. And then when the government is targeting speech directly, if it's content based, it's subject to strict scrutiny, which means that the government must show that the action is necessary to achieve a compelling interest, is narrowly tailored, and is the least restrictive means possible. Whereas if it's a time, place, and manner restriction, it's going to be a heightened form of intermediate scrutiny, where it's narrowly tailored to an important government interest and leaves alternative avenues of communication. So time, place, and manner is a heightened intermediate scrutiny, whereas content-based is going to be strict scrutiny. Look at the forum. If it's a public forum, like a sidewalk, or if it's a designated public forum or limited public forum, like a, private university that's hosting a presidential debate, or if it's a non-public forum, like a prison or a military base, then it's a viewpoint neutral discussion. And then if it's just a private forum in general, like my house, then there's no regulation, right? So yeah, freedom of speech heavily tested. For the con crim essay, I'll kind of just kill this bird with one stone here. It's pretty much Fourth, Fifth, and Sixth Amendment. I skipped second and third. Second is your right to bear arms. My motto is books up, guns down, but Floridians do love their right to bear arms. So, if there's a question about bearing arms, it's tough to impede on that right in Florida, especially. When it comes to the right to read books, I think actually, never mind. So yeah, Fourth, Fifth, and Sixth Amendment. Third Amendment too, you don't need to worry about. That's your right not to have to shelter a soldier during wartime, which hopefully shouldn't come into play anytime soon. And then the Fourth, Fifth, and Sixth Amendment. These are the con crim amendments. So Fourth Amendment is your right against unreasonable search and seizure. And I want to caution everyone with something that they need to know. If the essay says only write about the issues that are seen under the Florida Constitution, well, that also is going to include Fourth, Fifth, and Sixth Amendment considerations from the federal Constitution, because the Florida Constitution mirrors the federal Constitution in most respects. In fact, Florida even has an express heightened right to privacy. Oh, Grace, I have that shirt too with my face on it. I'll give you that one too. That Andrea made. I have that one. So anyway, the Fourth Amendment is reasonable expectation of privacy and your right against unreasonable searches and seizures. And when do you have a reasonable expectation of privacy? Well, remember, in Florida, you have an express heightened right, and you should mention that. And you'll have one, in your papers and effects and belongings. You'll have one inside your trash can in the house, but not at the curb, right? And you can kind of go from there. A really great mnemonic for Fourth Amendment is the exception to the warrant requirement. And I use the mnemonic spaces: search instant to arrest, plain view doctrine, admission in court. Wait, I just messed that up. Sorry, I was thinking about three things right there. Scratch that. The space is mnemonic: search instant to arrest, plain view doctrine, automobile exception, consent, exigent circumstances, and stop and frisk. That's the problem with mnemonics. You start mixing them up in your own head. I just did swap and spaces, mixed them up, right? Just so we can clarify that, SWAP is the exceptions to the statute of frauds, which stands for specially manufactured goods, written confirmatory memo, admission in court. promissory estoppel and performance, whereas spaces is the exception to the need for a warrant, which is search and to arrest, plain view doctrine, automobile exception, consent, exigent circumstances, and stop and frisk. They can also search highly regulated industries like a junkyard or something. But, in general, they need a warrant or they need probable cause to do a search. The warrant has to be issued by a neutral magistrate and accurately describe who's to be arrested or the items to be searched. Think of the exclusionary rule here and the fruit of the poisonous tree doctrine, where evidence that's seized in violation of the Constitution will be suppressed from evidence under the exclusionary rule, and then anything that's discovered as a result of the impermissibly seized evidence will also be excluded as fruit of the poisonous tree. There could be the good faith exception or the inevitable discovery doctrine. Right? Remember to argue both sides about why the evidence could come in or why it would be suppressed. Fifth Amendment, what's tested on the Fifth Amendment is due process. So your procedural and substantive due process. Procedural is notice and hearing. Substantive is your right not to be deprived of life, liberty, and happiness, and then and property, and also the takings clause from the Fifth Amendment heavily could be tested, right? A regulatory taking or possessory taking or a per se taking. A per se taking is like if they stick a stop sign in your yard. A possessory taking is if they take your land for public use, right? Like they did with the houses in Little Havana for the Marlin Stadium, right? And then a regulatory taking is when a government regulation renders your property economically unviable or deprives the owner of their investment-backed expectations. So that would be an example of a regulatory taking. And when there's a taking, regulatory, possessory per se, the affected party is entitled to full compensation in Florida. So Fifth Amendment due process, takings clause, and then it also has the criminal ramifications that could come up on a crim pro essay, which would be the right against double jeopardy, the right against self-incrimination, which applies in civil and criminal proceedings and even in grand jury proceedings, and then the Miranda rights. Your Miranda rights are your right to remain silent, that anything you say can and will be held against you, that you have the right to an attorney, and that if you cannot afford one will be provided for you. Miranda rights apply when a person is subject to a custodial interrogation. So if there's anything that's elicited as part of a custodial interrogation without receiving Miranda rights will be suppressed from evidence. Again, you're going to argue both sides on this issue. So the difference between Fifth Amendment right to counsel and Sixth Amendment right to counsel is a Fifth Amendment right to counsel is when you're in custody, whereas the Sixth Amendment right to counsel is after charges have been filed. So Sixth Amendment protects your right to counsel after charges have been filed, which is offense specific, the confrontation clause, and the right to a speedy trial. Seventh Amendment federally is a right to a jury trial, which has also been, mirrored in the Florida Constitution. So you have the right to a jury trial for actions at law, meaning there's monetary relief. Eighth Amendment is the right against cruel and unusual punishment. The 10th Amendment is state sovereignty, where the states can govern themselves so long as they're not preempted by the Supremacy Clause. A way to think about 10th Amendment state sovereignty is very similar to home rule power in Florida. Under the home rule power, municipalities have the authority to enact rules and regulations that do not conflict with the general rules of the state of Florida. Under the 10th Amendment, the states have the right to police themselves and to create laws that do not conflict with the federal laws, right? So very similar, home rule power and state sovereignty. It's just on what level. So 11th Amendment is sovereign immunity. Florida has waived sovereign immunity in tort for operational but not planning decisions. So like if they're operating the parade, then that's operational. If they're the ones who actually plan the parade and they, take responsibility for planning it, then that would be subject to sovereign immunity. Sovereign immunity means you can't sue the state unless you're suing an individual in their official capacity for injunctive relief. And it also means that the states can't sue the federal government. The states can sue themselves and the federal government would have, the Supreme Court would have jurisdiction over that matter. So then the 13th Amendment prohibits racial discrimination. It abolished slavery, but that also applies to private practices and then private establishments. And then the 14th Amendment is heavily tested. Remember, pretty much every common law essay, you want to talk about due process, equal protection, suspect classes, and these types of things. So 14th Amendment is where we get equal protection, which applies due process to the states, and it also establishes equal protection, uh, which gives levels of scrutiny for governmental action when it's targeting a specific group or class. So the difference between equal protection and substantive due process is substantive due process is a deprivation of all people's rights. Equal protection is the targeting. And if it only, impacts them as a result, but it's not intended, then that's not going to trigger heightened scrutiny. Heightened scrutiny is when it can be shown that the action is targeting a specific group or class. So strict scrutiny is necessary to achieve a compelling government interest and is narrowly tailored and the least restrictive means possible. Intermediate scrutiny, the government needs to show that it's substantially related to an important government interest. And then rational basis means the plaintiff has the burden of showing that the state the government action is not reasonably related to legitimate government purpose. Strict scrutiny applies to fundamental rights. Fundamental rights in Florida are like race, alienage, national origin, disability, the right to vote, the right to travel, the right to work, the right to unionize, the right to bear arms, the right to privacy, the right to trial by jury, the right to access courts. All these things would access strict scrutiny, fundamental rights. Intermediate scrutiny would be like uh, gender illegitimacy, and then rational basis would be for everything else, wealth, age, whether someone's a felon or something like that, right? So definitely, be strong with those conversations about scrutiny levels, fundamental rights, and deprivations of due process and equal protection claims. I mean, these come up all over common law essays. Every common law essay, in my opinion, should start with a quick analysis of standing, of justiciability, and of state action, right? There must be state action to involve the Constitution. There must be standing, so the person bringing the claim must show injury, causation, redressability, and there must be justiciability, meaning it's ripe and not moot. I think the hardest issue to see in con law, and I tell my students to look for this one proactively. In fact, just write about it. I don't care what the essay is about. If you get a con law essay, put this word on your paper. Put these words on your paper. These three words: separation of powers. Just put that on your paper, separation of powers. And you know what? Put vagueness and overbreath too, right? I don't care what the essay is. The law that as enacted is vague and overbroad, and it potentially implicates the separation of powers doctrine. I mean, that's just pretty generic. For separation of powers, you're thinking of entanglement, entwinement, usurpation, encroachment, right? Divesting the authorities of one branch and giving them to another. These are, heavily tested concepts when it comes to con law. And then in Florida, we want to think about sunshine law and homestead exemption. Sunshine law meaning that all governmental proceedings need to be under the sunshine. There's a right of access unless it's for two legislators in an unplanned meeting, right? But the sunshine law is definitely heavily tested. And remember, you can compare the sunshine law versus the right of privacy, but the sunshine law will prevail if it's a governmental proceeding. There will be a right of access, despite their argument for heightened privacy in Florida. Homestead exemption is going to protect half an acre inside a municipality and 160 contiguous acres outside a municipality from judgment creditors. And the homestead is your primary residence for the husband, the wife, the minor child. The creditors who can pierce the homestead would be like mortgages, liens, judgments on the property itself, and then government taxes and judgments. Yeah, con law, homestead exemption, sunshine law, enacting a law or ordinance in Florida. So first you need to propose the bill, then you need to pass the law. The bill needs to have a clear subject, a clear title, a single subject, an enacting clause, be enacted in the state of Florida. It needs to be related to the health, welfare, and morals of the people. It cannot be vague or overbroad. And then it needs to become law by passing in both houses and being read 3 times in a process known as bicameralism, right? Both houses speaking together, and then be presented to the governor for signature. Florida does not recognize the pocket veto, which is recognized in federal. There could also be a special legislative session called by the governor to discuss issues, and they can only discuss the issue is called for unless they get a 2/3 vote by each house. You need a 60% vote to change an amendment on the Florida Constitution. You can remember when marijuana and abortion were on the ballot recently. It was a 60% vote, so it got over 50, but it didn't pass because it wasn't quite 60. Florida has general laws, special laws, and general laws of local application. General laws will apply to the state uniformly, whereas general laws of local application are based on population. Special laws apply to specific counties and are subject to a referendum or a vote by the actual county itself. Florida, like I said, has chartered and unchartered counties. Chartered counties, their municipalities have home rule power, a special vested power, which enables them to enact laws and ordinances which do not contradict or are not preempted by the general laws of the state of Florida. Remember, ad valorem taxes, property taxes are levied by the local governments, not by the state. Different types of bonds include municipal bonds, general obligation bonds, which are backed by taxes and are subject to a vote, and then revenue bonds, which are backed by the revenue of the actual project, and they'll be subject to feasibility studies. But yeah, those are different concepts. Florida, if you're a felon, you don't have the right to vote or the right to serve in office unless you've had your voting rights restored or you've been granted clemency. Florida has constitutional officers like mayor, the governor, the let's say the sheriff, the appraiser, the CFO, and they have, vested rights and have to take certain ethical courses to do their jobs. But just pretty much on a con law essay, they're going to give you some act or ordinance most likely and ask you what are the arguments against the constitutionality of this act. Always start with due process, equal protection, vague, overbroad, it wasn't enacted properly. Then, make sure you talk about standing and justiciability and state action, and then start getting into the creative arguments, right? That like maybe this is a sunshine law, or maybe this is a homestead exemption, or maybe this is a separation of powers issue, or whatever it may be. But just try to have a general discussion and talk about as many issues as possible, and don't leave anything out because it's con law, it's very subjective. Florida recognizes the Kluger Doctrine. The Kluger Doctrine means that the state can impact or they can restrict access to courts and other fundamental rights if there's an overarching public necessity. So that's known as the Kluger Doctrine. If you're writing about the Kluger Doctrine on test day, you're killing it, right? Other students don't learn this. Only Ibis Prep students do, right? So hopefully, I've hit you with some really good pieces of con law, right? About con crim, 4th, 5th, 6th Amendment, exclusionary rule, fruit of the poisonous tree, Miranda rights, and reasonable expectations of privacy. Federal con law, standing, state action, justiciability, First Amendment, Fifth Amendment, 14th Amendment. Other issues you can see ex post facto. They can retroactively punish people for criminal laws. Impairment of contracts, right? If they impair existing public or private contracts, and then bill of attainder if they punish someone without giving them a judicial process. I mean, all these constitutional considerations can be discussed. And then Florida, be sharp on sunshine law, homestead exemption, enacting a law in Florida, general law versus special law versus general law of local application, home rule power, Kluger Doctrine. These are some of the things that you can anticipate, but always try to incorporate that separation of powers issue, the entanglement, entwinement, usurpation. Yeah, access to courts, right? That's something that could be tested, or having unreasonable bond conditions, right? They hold someone in jail for too long and they don't give them a right to release, and they're not a threat to the judicial process. Just stand in the shoes of the criminal defendant and try to argue their rights, and and see what constitutional considerations there can be. Con law is very tough because it's three, I'd say, lenses: the con crim lens, the Florida con law lens, and the federal con law lens. But just on test day, try to take from everything you know and write these really robust, rule drenched answers that have analyses and counter arguments. Real property, I think, is the toughest subject on the test, to write about, right? A lot of things to know. Remember, real property and contracts kind of bleed together in many senses, in the sense that a contract for real property needs to be in writing in order to conform with the statute of frauds. You might be looking at the contract and see if there's been any, uh, let's say, failure to disclose or concealment or misrepresentation. Under Johnson v. Davis, residential sellers of real property have a duty to disclose latent defects that they knew about or should have known about. So there could be that whole discussion. Deed formalities, if they actually record the deed, then the deed has to be attested and signed by two witnesses and accurately describe the property. There's different types of deeds, like a general warranty deed, a quitclaim deed, and a special warranty deed. A general warranty deed has the 6 covenants, the 3 present covenants of seisin, the right to convey, and the right against encumbrances, and the future warranties of further assurances, general warranties, and quiet enjoyment. A special warranty deed only warrants for the time that the possessor had title, and then a quitclaim deed gives no warranties. All sales of property come with the implied warranties of marketable title, meaning there's no encumbrances or easements or any liens on the property. And remember that the contract will merge with the deed during that period of escrow. And under the theory of equitable conversion, when the contract has been signed, but before the deed has been recorded, the risk of loss will pass to the buyer. Florida is a lien theory state, and Florida is a pure notice jurisdiction. A lien theory state means that a loan on property operates as a lien, not title. So if two parties are joint tenants with right of survivorship, and one party takes a loan out on a property, that'll be a lien on the property, not title. So if that party were to die, then the lender could not collect from the property itself. They can only collect personally from the borrower's estate. A pure notice jurisdiction means that subsequent bona fide purchasers will prevail. A subsequent bona fide purchaser is someone who takes for value in good faith without notice. For value was with money. In good faith means not bad faith. And then without notice means they didn't have actual inquiry or record notice. So if they had notice, then they're not a bona fide purchaser. So make sure you recognize that Florida is a lien theory state and that Florida is a pure notice jurisdiction. With a landlord-tenant situation, there's different types of tenancies. I like the mnemonic: your period will suffer, tenancy for years, periodic tenancy, tenancy at will, and tenancy at sufferance, like a holdover tenant. Florida's a no self-help state, so you'd have to get a sheriff or someone to evict the landlord. In Florida, you have to deliver the legal and actual possession, so the landlord could be responsible for a holdover tenant. The tenant has the duties to pay rent and not commit waste. Waste can be actual, permissive, or ameliorative. These are the same duties that are owed by a life estate tenant, right? To not commit waste. The waste doctrine could definitely test it. And then the landlord has the duties of habitability and quiet enjoyment, right? And those are some key pieces of the landlord-tenant type of essay. There's adverse possession, which is when someone acquires property and it's open, continuous, exclusive, adverse, notorious, and hostile. The statutory period in Florida is 7 years. You can claim with color of title or without color of title. Color of title means appearance of title, like a defective deed or some document that purports title. If you claim with color of title in Florida, you just need to make some improvements or enclosure on the property. If you claim without color of title in Florida, not only do you need improvements or enclosure, but you also need to have paid the taxes on the property. You could get a tax credit or a tax deed. A tax deed means that there's outstanding taxes, and once you pay for it, you receive a tax credit, which shows that you've paid off the taxes on the property. Just lightly, they could test like fee simple determinable, fee simple subject to conditions subsequent, or fee simple subject to an executory interest. Shifting executory interest is grantee to a new party. Springing executory interest is grantor to a third party. And then determinable is durational language, that would mean automatic reversion, whereas condition subsequent means that there's conditional language that leads to the possibility of the right of reentry, right? So automatic reversion or right of reentry. With real property, Florida, they test mortgages a lot, right? A mortgage is a loan secured by property, and the borrower is the mortgagor, the lender is the mortgagee. If it's a PMM, a purchase money mortgage, they'll have super priority. Otherwise, it's first in time, first in right. In the event of non-payment or default, the lender can seek a foreclosure action, which is the forced sale of the property, to pay, which will pay off the senior mortgagee, and then junior mortgagees will need to seek a deficiency judgment from the homeowner, right? So think about how homestead exemption, lien theory, pure notice jurisdiction, these things could all come into play when we have some sort of a foreclosure action or some sort of mortgage discussion. Remember, adverse possession is how you can acquire title to property. Title can be by deed, it can be adverse possession. It's a position of ownership. An easement is a right of use, different than a license, which is only temporary. Easements could be affirmative or negative. Florida does not recognize a right to a view. That's the landmark case of Found Blue versus Eden Rock. There's two landmark cases in real property that stem from Florida. Found Blue versus Eden Rock, no right to the view. And then Johnson v. Davis, the duty to disclose latent defects in the sale of residential real property. So easements can be affirmative or negative. The only negative easement recognized in Florida would be riparian rights, water rights. You can't disrupt the reasonable use of your neighbor's water. And then we have easement appurtenant and easement in gross. Easement appurtenant is tied to the land. Easement gross is personal in nature. We have easement by prescription, which is open, continuous, actual, notorious, hostile for the statutory period of 20 years in Florida. And then easement by necessity when a property is hemmed in and has no access to a public road. And then there's express easements and implied easements. So, you can talk a lot about easements. The remedy for overuse of an easement is a surcharge or injunctive relief. It won't be termination. It's pretty difficult to terminate an easement unless there's, merger or estoppel or an express agreement to do so. But property is a tough subject because there's multiple blueprints. It could be the landlord tenant, it could be some conveyance, or it could be some like neighboring issue where there's like are they subject to a real covenant or equitable servitude? Real covenants are promises on property that are remedied by legal relief. Equitable servitudes are promises on real property that are remedied by injunctive relief. In order for them to run with the land, they need to be notice, intent, touch and concern the land. They should be in writing, and there'd be some sort of privy between the parties. I mean, if you want to get a perfect score, then you could potentially mention that some conveyance might violate the rule against perpetuities. No interest in land is valid unless it must vest, if at all, within 21 years of the death of a life and being at the time the interest was created, or actually vest within like 1,000 years in Florida. So real property is really, really tough subject. They tend to focus on like, deed formalities, misrepresentation or failure to disclose issues, lien theory state, pure notice jurisdictions, inquiry notice, actual notice, record notice, waste doctrines, and easements, mortgages, adverse possession, just the whole nine. For those of you who have access to my book, in the real property section, I have all these vocabulary words, which I think are really helpful. The more vocabulary words you know for real property, the better you can expect to do. Does anyone have any questions at all about anything? I gotta take a bite. I'm so hungry right now, and I had breakfast this whole time, but just give me 1 second. I can't remember that good when I'm hungry. I'm like, feel a little off.
Hmm.
Yeah, make sure you eat a good meal. the day of the exam. You want to be well fed and definitely well hydrated. This administration, I've had a student apprise me of the color of their urine, so I think it's been important that it's as clear as possible on test day. What's up, Diego? You got a question?
Yeah, I have a quick federal common law question. When
Uh-huh.
you brought up that that judiciability means that a case is ripe for court, so does ripeness mean that it's actually going to bring the case to court, or is it too early for the case to actually be introduced into court?
So you want to make sure that a case is ripe and not moot. Ripe means that it is an actionable injury, meaning like you're not planning to open up a restaurant. You already own the restaurant, right? So if there's an action that says there's no, Mexican food restaurants allowed in Miami, and I'm like, oh man, I was gonna open one up next year. That's not a ripe industry. But if I already had, yeah, like Grace is saying, a fruit is ready to eat. And then moot means that it's not too late. Like, um, there's a construction saying that they're allowed to build a bridge, and people are like, no, we don't want this bridge to be built, so they're suing. But then the bridge is already built, and now they're trying to sue to enjoin them from building the bridge. It's like it's moot already. The bridge has already been built. So good questions. Honestly, those two bites help me. I feel like a new human. I just get one sip of this apple juice.
Cool. Thanks for the clarification.
Yeah, for sure. All right. So then, after real property, I think we can talk about family law. Family law, we're praying for a family law essay. My prediction is probably the one that, not probably, but my prediction is it may not be tested this time, but it could definitely be. And if it's tested, you got to recognize that Florida, as a no-fault divorce state, will allow divorces if the marriage has been irretrievably broken or one party has been adjudicated incompetent for 3 years. We want to think about the parenting plan, which will have all the, time sharing agreements. And we don't like to have sole custody or sole time sharing because you have a constitutional right to the upbringing of your child in Florida. Um, Alimony and child support. Remember, child support cannot be waived in a prenup or a postnup, whereas alimony and equitable distribution can. Equitable distribution means that property is going to be divided equitably. So you'll look at marital property and non-marital property. Marital property was acquired during the marriage. Non-marital was before the marriage or individually, like gifted or bequest, let's say. And equitable distribution, not necessarily evenly, but equitably, considering all sorts of factors, right? When you're doing the family law factors about equitable distribution, alimony, child support, it's very logical. Just as many, factors that you can think of that would apply between spouses or for children or for whatever it may be. Child support always in the best interest of the child, and the different factors that may apply. And then alimony. So we've abolished permanent alimony very recently, but you can still be grandfathered in if you're already given it. Then there's durational alimony. Then there's rehabilitative alimony. There's temporary alimony. There's bridge the gap alimony, and there's pendente light alimony. Just talk about all the different types of alimony. You know, uh, I think um, a long-term marriage is over 19, short-term marriage is under 10, and then like I think 9 to 19 is what they do it, is a midterm marriage. They changed that rule recently too. But just in general, the length of the marriage, the contribution, how much money one party's making, whether one party was adulterous or not. One of my friends right now, his sister, you know, she shouldn't have got caught because now it's really going to affect her. Now she's gonna have to pay alimony and child support for the rest of her life, probably. But that's neither here nor there. So, with alimony, child support, uh, equitable distribution, and then modifications. Modifications will be granted if it's for something that was a substantial change in circumstances. It no longer needs to be unanticipated. And then under the UCCJEA, that's how we determine jurisdiction, the uh, Uniform Child Custody Jurisdiction Act. Wait, UCCJEA, the Uniform Child Custody Jurisdiction Enforcement Act, I think, would be that the court that issues the final marital settlement will have exclusive continuing jurisdiction exclusive continuing jurisdiction over the matter unless they give it up. So, just my general advice, if there's a Georgia case and a Florida case and they're asking where his, jurisdiction proper, it's probably gonna be proper in a Florida case. It's a Florida exam, and you wanna, discuss Florida law. So, 6 month rule where the child has lived for the last 6 months or where any of the parents have lived, if it's a divorce case. Um, Adoption rights, you can have a kinship adoption, which is like by a relative, which is much quicker. Adoptive parents have the same rights as biological parents. And again, it's very hard to divest someone of complete visitation rights to their child because you do have a fundamental right to be involved in the upbringing of your child. Remember, it's I think, locus parenti doctrine, where like ultimately the state will take care of the child if the parents are deemed unfit. So, with family law, really just make sure you know the different types of alimony, that child support cannot be waived, and that it's always about the best interest of the child, that a modification needs a substantial change in circumstance, and that under the UCCJEA, you'll have 6 months for determining jurisdiction, and the court that issues the final uh, settlement will have exclusive continuing jurisdiction. What's up, Alexa? You got a question for me?
Hi, yeah, really quick. I know for modification, it needs to be a substantial material change, but is there anything that cannot be modified? Like a clear rule that just can't be modified? Or no? Like anything
Well,
can be
I'd say
modified.
equitable distribution. You know what I mean? Because once you distribute the property,
Right.
you can't really go back and be like, oh, give me a cut of that pie.
Okay.
For child support and alimony, I can't really think of a time where it couldn't be modified because at the end of the
Okay.
day, it's best interest of the child. When it comes to the child, we're not going to have any limitations. We got to protect the child. When it comes to the um, alimony, yeah, like the thing is, it can be waived in agreement ahead of time, and that's an instance where I'd say you couldn't
Okay.
modify. Yeah, but like in general, it's very fact pattern
And
specific.
then
But
child support just can't be waived. That's like the main one that just can't be waived, right?
well, the way that Florida operates, and you should go back to Marion and Emily's lecture on this, is that Florida has these statutory guidelines where that's how much based on your income,
Right.
and you can't deviate for more than like 5% or 15% without petitioning. So like there's that type of a of limitation on it, right? That you have
Right.
to follow the statutory guidelines. Yeah. Um,
Thanks.
okay, nice. So yeah, 5%. That's what I thought. All right. So rehabilitative alimony for up to 5 years, bridge the gap is up to 2 years, and the default rule for child support is that order is valid for 3 years and may be modified under the correct grounds. And yeah, 5% deviation from the statutory guidelines will require some, explanation and petitioning. All right, and then ethics. So ethics, I think, is pretty manageable, right? They start off with where do the rules of ethics come from? They come from the Supreme Court, they come from the oath, they come from, you know, swearing into the bar, they come from the federal rules of the Florida rules of professional conduct. There's all these different documents that give us these rules of ethics. And then if you violate these rules, you could be subject to discipline. The most heavily tested ethical rules are conflicts of interest. So if, there's a conflict from representation of another client, the attorney can only represent the current client if they reasonably believe they can offer sound counsel any um, without any sacrifice of the conflict. And then they need to get the written consent of the client. So they need to either be able to reasonably believe they can do the representation and get the written consent. This conflict of interest can be imputed to other members of the firm, and they need to be screened out um, if they want the firm to represent it and there's a potential imputed conflict. So make sure you can write about conflicts of interest. Then, different duties of decorum, duties of candor, duty of competency, um, confidentiality, which is even greater than the attorney-client privilege, right? These duties have to be upheld. They test a lot about referral fees and contingency fees. Again, both of them should be in writing and signed with the consent of the client. And the referral fees are not allowed unless the referring lawyer actually participates in the litigation and gets the consent. And then contingency fees need to be calculated in advance and a final calculation when they're distributed. And again, the written consent of the client. And they all need to be, reasonable and things of that nature. So they test the fees arrangements a lot. They test the different duties, and then they'll test potentially like advertisements and solicitations. You can't solicit an accident victim for the first 30 days, and then advertisements have to be, truthful. They can't be false or misleading, and they need to have your name, bar number, address, and different things that lead to ethical respect in the field, right? So when I tell people to write about ethics, I often tell them write that first. Take 8 minutes and just crush the ethics piece. Write about all these rules, and then get back to your essay. But don't be someone who gets to ethics and then writes one sentence and runs out of time. It's not the main part of any essay, but it's a part that you do want to get your points on. So make sure that you're pretty solid with ethics, and you know it's going to be tested. And that's why I often tell people that might be the last thing I study. And when people are like, what do I study down the stretch for essays? I'm like, you might as well study the shit out of ethics, because you know it's going to be tested. And then con law, because it'll probably be tested in some regard. And then, in order, I think property, towards contracts, family law. I mean, you want to study them all, but at the end of the day, I hope everyone learned from this lecture that the Florida essay section is manageable. You should be able to do what I did, go through every single subject, articulate the rules of law, and I think you'll do just fine. For Florida multiple choice, I can't really do the same thing or just give you these blueprints and things that you need to write about, but I'll try my best to give you some key fundamental pieces from the different sections, and then I'll give you guys a little game day speech and send you on your way. If you're a Berry student, I'm doing a Q&A today at 2 o'clock. And if you're a UBE student, which would make absolutely no sense, I'll be doing a session from 4 to 7 today. And then tomorrow I'll do 11 to 1 MBE, and then we'll do one last proctor exam 4 to 7. I got a couple students that booked me for Monday to Tuesday, and then forever vacation, retirement, right, Grace? Okay, so for Florida civil procedure, you definitely want to know the life cycle of the case, how it would be filed. Remember, 120 days, not 90. And then on the other end, remember, you have 15 days for the new trial and for the belated directed verdict, not 28. So, like, understand the dates and times is a huge place for civil procedure. We have, the Florida federal distinction sheet. That's probably that, and the Florida evidence distinction sheet. I mean, those are the two things I would be focused the most on down the stretch before the Florida multiple choice test, right? That and the FBB questions. So remember the 120 days at the beginning, and then the 15 days at the end for belated or new trial. It's still going to be 30 days for the appeal and 1 year for the relief from judgment. It's the same standards like for the motions to dismiss that it is in federal, where you can bring SMJ and failure to state a claim for which relief can be granted, and failure to join a necessary indispensable party. They don't need to be brought in the first opportunity, whereas the venue, the PJ, the process, the service of process, they need to be brought in their first opportunity, or they're going to be waived. It's the same standards too, like summary judgment, no genuine disputed material fact. Directed verdict means substantial evidence in light of the moving party, or no reasonable juror could find for the non-moving party. And then new trial would be the verdicts against the weight of the evidence, or juror misconduct, or the substantial rights were prejudiced of the party, something of that nature. There's the concepts of impleader, bringing a party into the action, interpleader, forcing two defendants to litigate amongst themselves over dispute, and then intervention, which is a third party uh, jumping into the claim from the outside. There's been a couple changes recently, I guess, to summary judgment and discovery, just to make it a little bit longer. I don't even want to mix them up so you guys can uh, reinforce them. But as I was asking Grace, who's taken this test a few times in a row, I'm like, is there anything that's repetitive that you've seen on every single test on civil procedure? And I really can't say there is. You got to know SMJ, PJ, and venue. PJ is uh, where they're domiciled or where the corporation is incorporated in their principal place of business. SMJ, it's talking about like small claims court is 8,000 and under, and then county court, and then district courts, and then Supreme Courts, and like the big cases will go to the Supreme Court, and bond validations will go to the Supreme Court. Um, and then, that's the order of what size court we're in, right? Something I wanted to mention earlier, I guess, in family law or in ethics is you can't have contingency fees in domestic, divorce cases, child support cases, or in criminal cases. But yeah, civil procedure, the life cycle when you could have a motion to judgment on the pleadings very early on, or a motion to dismiss very early on, or an affirmative defense pretty early, versus a summary judgment after discovery, or a directed verdict before the verdict, or belated after the verdict, or a new trial or an appeal, and then a relief from judgment. Like that's kind of the order of how the life cycle continues. Um, Civil procedure, I think is a pretty tough subject to lecture on because it's just about dates and times and the filings of certain things. But it's the subject that if I were a student, I would spend the most time down the stretch really focusing on because it's guaranteed to be tested. And, just doing practice questions will really help you out in that regard. For criminal procedure, I think what's really important to understand is the same life cycle of the defendant and their rights when they're put through the process. So they are arrested and they're entitled to a first appearance within 24 hours. Usually at that first appearance, they'll have the first appearance, they'll have the arraignment, and they'll have the non-adversarial probable cause determination if there hasn't been probable cause yet, right? Like that's a way of getting all those things done early. But there are timing restrictions. You have 24 hours for the first appearance. Then you have 48 hours for the non-adversarial probable cause determination hearing if they are in custody and they weren't arrested upon probable cause or warrant. And they can get two 24-hour extensions by the state for that one. So it could be 48 plus two 24-hour extensions to actually make it 96. Then if they're a felon and they're charged with a felony and they're in custody and there still hasn't been probable cause determination, they'll have an adversarial probable cause determination 21 days later, within 21 days. So you have the 24 hours for the first appearance, 48 plus 224 extensions for the non-adversarial cause determination hearing, 21 days for the adversarial probable cause determination hearing if there's need for one. And then you have the 30, 33, 40 rule when charges need to be filed or need to be released. If charges aren't filed within 30 days of the arrest, they need to be released on the 33rd day, unless they can extend it for 7 days and be released on the 40th day. Then there's the speedy trial rules, which are like if a demand is made, then they have 60 days from the demand. If no demand is made, then it's 90 days for the misdemeanor and 175 days for the felony. If you're charged with a felony and a misdemeanor, you'll get the 175 days. They've changed, a few things, but importantly, the recapture period is now 30 days. And what that recapture period means is, okay, just because you filed the notice of expiration of speedy trial time doesn't mean that, uh, the charges are dropped or whatever. They have a recapture period where they have a hearing and then time to bring you in to trial. So that's what the speedy trial dates are all about for criminal procedure. Criminal procedure, Florida has the insanity defense. It's clear and convincing evidence. It's a lot on Florida and civil criminal procedure. There's a lot on Florida civil and criminal procedure. And like I said, it's not the same as like an essay subject that I could just lecture on, but I really encourage people to, really understand if you're looking at Florida civil procedure, try and walk yourself through the entire case as the plaintiff and as the defendant and try to make all the motions and figure out what times you have to make them and why you'd make those motions. If you're thinking about Florida Crim Pro, do the same thing, but put yourself in the shoes of a criminal, which could be fun, and then walk yourself through, all the ways that you get arrested and then lead all the way to, the sentencing, right? And the jail time and all the different things that you could be entitled to and, your right to counsel. And if the judge puts in writing that you're not going to serve any jail time, you don't need the right to counsel, right? All these things I really believe can be mastered through the practice questions, especially the FBBE practice questions. For evidence, I think evidence is the toughest subject just because there's so many distinctions between Florida and federal evidence. For instance, for judicial notice, we're at federal, if they take judicial notice, then in a civil case, they must accept it as conclusive. In Florida, it doesn't matter if it's civil or criminal. If they take judicial notice, they have discretion. They may, but are not required to accept it as conclusive. Another distinction is that Florida doesn't recognize the learned treatise doctrine only on the impeachment of an expert witness on cross-examination. Also, for the marital communications and testimonial privilege, Florida does not have that testimonial privilege, only for the communications. And that communications privilege will not apply if the spouses are now parties against each other. There's no hearsay exemptions in Florida, only hearsay exceptions. So, for instance, a party opponent admission is a hearsay exception, and a statement against interest is a hearsay exception, but it requires the unavailability of the declarant. For the dying declaration, where at federal it has to be civil or homicide cases, we'll allow dying declarations in all cases in Florida, civil or criminal cases. There's exceptions for like statements expressing sympathy and just all sorts of exceptions. Again, I've really boiled this down, and Danny's helped with the worksheets for Florida evidence, Florida civil, and Florida criminal procedure. I'm telling y'all, I guarantee procedure is going to be tested. And then I'm really expecting Florida evidence to be tested because it wasn't tested last time. It would be pretty shocking if it wasn't. And if you think about it like this, Florida evidence, if tested, is the greatest weight on the exam. You want to hear the math? It's the only subject, right? On the essays, they're all mixed. You never get just one subject. It'll be property and common law, or it'll be torts and ethics, right? They're always mixed on essays. On the multiple choice, they're always mixed, right? Procedure, you're going to get 30 civil criminal questions. If it's estates, you'll get 30 wills and trust questions. If it's business, you'll get 30 corporations, partnerships, secure transactions, and commercial pay. Like that's 4 subjects in one. But if you get evidence, it's going to be 30 questions on Florida evidence, right? So if it is tested, then it's going to be heavily weighted, right? So like Jim Nelson, who I talk a lot about, how he got an 89 last time, he got really lucky because evidence was his worst subject and it wasn't tested. So now this time I think it probably will be tested. And if it is tested, it carries extreme weight. Do you understand that math I just gave? That like that is the only subject that's in its own ballpark, where every other subject, if you think about it, is kind of joined when it's tested. So if you're, thinking about what should you do down the stretch, I would definitely dial in on evidence, and I would dial in on Florida civil and criminal procedure just because it's always tested, and those, those are the big ones. So definitely dial in on them. All right, wills and trusts, which I think is more likely to be tested than business entities, commercial paper, and secure transactions this year. So for wills and trusts, wills understand per stirpes distribution, which means that if it's an intestate distribution, it's going to occur on the first generational level. So if A is a widow and dies and has 3 kids, B, C, and D, they'll each get 33%. If D's dead, then D's kids will take that 33% to on the stirpial distribution. Remember that Florida has the 30% elective share, so you can't really write your wife or husband out of the will. Florida does not recognize holographic wills. we do not recognize common law marriages unless they were validly recognized in the other state and then they came here. Um, so there's will formalities. It needs to be signed in the presence of two witnesses, right, who also need to attest to it. A will in Florida cannot be revoked by partial act. It has to be revoked entirely with intent. A codicil is an amendment to a will, and if there's intent and revocation of the codicil, it'll revoke the codicil, but it won't revoke the will. If there's intent and physical act to revoke the will, it'll also revoke the codicil by extension. A will can incorporate like a list, and then that list will be incorporated into the will. And in Florida, a revocation of a second will not automatically revive a first will. In Florida, if you die intestate and you have a wife, she'll take everything. If you have a wife and kids from a previous marriage, the wife will take 50% and the kids from the previous marriage will take 50%. And you got to understand how homestead will implicate will distribution, because you can't devise someone's homestead property in a will. And remember that a JTROS, a joint tenancy of the right of survivorship, that will supersede a will. So if there's a property that's between A and B is a JTROS, and then B dies and devises his interest to C, A will take the JTROS because that'll prevail over the will. I would say that the biggest thing that I would learn about for wills is intestate distribution. Go over some scenarios and some charts and try to really figure out, make sure you understand how property will be distributed upon death. Florida will not recognize no contest clauses, so anyone can contest a will. If a will is under $75,000, then they could have summary administration instead of full administration. I'm sorry, if the estate, no will. If the estate is under $75,000, they could have summary administration instead of full administration in probate. And then yeah, I think you guys will do just fine on Florida wills. It's a very manageable subject, but it can be very difficult. I think Marion did an extremely great presentation on wills, and for those of you who don't know, Marion got 30 out of 30 on wills on her exam. So she got a perfect score, and she did the presentation and made the PowerPoint. So you should feel confident in her PowerPoint that she's pretty much covered her bases. And then the professor who did trust, I know she's awesome, right? Rebecca, she will be there in Tampa, so you get to meet her and see her and maybe ask her a quick trust question before the test. But trust, remember, it's a settler who creates a trust, it's a testator who creates a will. A settler has to have intent, they have to have sound mind, they have to be over the age of 18, there has to be ascertainable beneficiaries, trust race, like present race, and there'll be a trustee. But remember, trustee with duties. But if a trust will not fail because of lack of a trustee, they will the court will put a trustee in for them. A trustee has the duties of loyalty and care, and just because the value of the trust goes down doesn't mean that the trustee has breached a duty, because the diminution in value of trust property doesn't automatically signal that the trustee has breached their duties. There's different types of trust. Trusts are presumed revocable in Florida. They're presumed revocable. Again, we do not allow no contest provisions. A totem trust is a POD, a payable on death account, like account that just pays to someone. There's a spendthrift provision or a spendthrift trust, which will protect the trust from outside creditors who can only take once distributions have been made. The only people who could pierce a spendthrift trust would be child support, alimony, and the government. But if you want to have a very safe trust for your, kid who spends money wildly, you would have a discretionary, irrevocable discretionary spendthrift trust. Discretionary meaning the trustee has discretion for disbursements. Spendthrift meaning it's protected from outside creditors, and irrevocable because irrevocable has more protections than revocable. Trust can be oral in Florida unless it's with real property involved, or it's testamentary in nature, which testamentary means upon death, whereas inter vivos is in life. There's a secret trust and a semi-secret trust. Secret trusts will be enforced. Secret trusts are mentioned in a will with beneficiaries. Semi-secret trusts are mentioned in a will, but they don't have beneficiaries. So how could we actually enforce them? And then I think what they love to test in Florida trust is a site-pres doctrine, where if property is left to a charity that no longer exists, then instead of it reverting back, it will pick a new charity that has a similar purpose. Going back to wills, just one thing is the concept of lapse, where if a devise is made to a person, that person doesn't exist, then it will be said the gift lapse. But Florida has an anti-lapse statute, which means that a lineal descendant of that person's grandparent can step in their shoes and take instead of the gift lapsing. Yeah, wills and trusts, I mean, they're not easy, not impossible. Definitely do practice questions, and I think you should do just fine. I'm expecting and not expecting it, but I would not be surprised at all if it's tested this administration again. And then the last thing is business entities, commercial paper secure transactions, which I said, if I were betting on one to not be tested, it would be this one. But as I told Barry law students when I gave my presentation, and I told you know, everyone every time, okay, just because statistically speaking, this is the administration where business entities, commercial paper, and secure transaction is statistically the least likely to be tested, but that doesn't mean that it's less than 50% likely to be tested. I want you to know that it's still probably more than 50% likely to be tested, even though it's the least likely to be tested. I think everyone is about 85% likely to be tested. This one, maybe let's say it's 74% likely to be tested. So like you can't say if it's tested, I was wrong. It's still likely to be tested. It's just the least likely to be tested. Now, again, just because something's the least likely to be tested, I told my Barry students this. All right, troops, the enemy's most likely going to attack from the west tonight. So don't worry about protecting the east. Well, shit, if we're wrong and they attack from the east, we're all going to wake up dead. Same concept here. Just because they might not test business entities doesn't mean you can't study for it. Because if they do test it, then you will fail. You will 100% fail. If you get cooked by one section, like totally cooked by one section, you'll fail. Whether it's essays, one of your 3 essays, or whether it's multiple choice, one of the 3 sections that's tested. You can't collapse on any section. You'll sink your ship with major weakness. So whatever your weakness is, try to turn into a strength by the end of the day, right? Okay, so business entities, we have first off partnerships, which we have these authority, right? Implied, express, and parent authority. Usually one partner can bind the other partner by their acts because there's some principal agent relationship which imposes authority. There's general partners and limited partners. General partners have management responsibility and unlimited liability. Limited partners are limited liability and they don't have any management responsibility. An LP has at least one GP and at least one LP. A GP has all GPs. Partnerships are presumed general partnerships, and they'll presume to split profits and losses equally. They should have a partnership agreement, but they don't need one, right? You only need formal agreements for like, an LP or LLP or a LLC or S corp or C corp. An LLC will file articles of organization. A corporation will file articles of incorporation. LPs, LLCs, PCs, PAs, PLLCs, S corps even, they're all subject to flow through taxation and limited liability, right? LLCs, right, could be member managed or manager managed. Member managed means that the owners of the LLC manage it. Manager managed means that the members will appoint managers who will manage the LLC, almost like a board of directors. Yeah, the partnership questions really about duty of loyalty, duty of care, and about binding each other with a parent or express authority. Corporations can be C corps or S corps. S corps an election of flow through taxation, whereas a C corp has double taxation and limited liability, right? You always have limited liability in corporations. Corporations file articles of incorporation in Florida, and they have to, describe the founding members and all the pertinent information that's on those documents that are actually filed with the Secretary of State, whereas the bylaws are they're not necessarily filed. So common shareholders have stake in the company and they get to vote. They get to vote on major corporate changes like amending the corporate charter, mergers, acquisitions, stock splits, most importantly, voting for the board of directors, who's going to be a member. Cumulative voting means that they can stack their shares for one member, and that'll benefit the smaller investor. And then preferred shareholders have dividend priority and liquidation priorities. They receive dividends before common shareholders, and in the event of liquidation, they'll get paid back before common shareholders. Common stockholders also could have appraisal rights or inspection rights, potentially. And then there's derivative suits and direct suits. A derivative suit is brought on behalf of the company, and the stockholder needs to own shares and make a demand upon the company or show that demand would be futile. And then a direct suit is when a shareholder sues the company directly. There's what's known as piercing the corporate veil, which is when someone wants to sue the board of directors or the owners or the parent company directly, and they could show that there's a improper purpose, alter ego, thin capitalization, or some means of piercing the corporate veil to go through the shareholders directly, or go to the shareholders or whoever directly, right? The owners directly. That's going to be piercing the corporate veil. The business judgment rule is a lot like the rule I told you about the trustee, where we're going to protect, board of directors for their judgments so long as they weren't, made in bad faith. But even if they have a poor outcome, they'll be protected by the business judgment rule. Remember, the board of directors serves at the pleasure of the shareholders, so they can be removed with or without cause. And the officers serve at the pleasure of the board of directors, who they can also, remove with or without cause. So if you see anything talking about blue sky laws, that's talking about intrastate securities, sales of stocks or bonds only within the state. If you see anything about Sarbanes-Oxley or Dodd-Frank, that's talking about look for the compliance answer. And then the tippy tipper, anyone who acts upon information or gives someone information that's acted upon, they could be held liable for a 10b-5 violation. Corporations, partnerships, I think are pretty tough subjects, right? Honestly, in my opinion, they're the toughest subjects on the bar exam. They shouldn't even be on the bar exam. I teach for the Series 7 and 66. I have my MBA, and that's where this stuff should be tested, not on the bar. But it is, and you got to be prepared for it. But just remember mostly the duties of the directors, the things that common shareholders get to vote for, and then the different types of entities: GPs, LPs, LLPs, LLCs, S corps, C corps. It's a lot of good stuff in there. And then finally, getting down to the wire, secure transactions, commercial paper. Commercial paper is Article 3. Secure transactions is Article 9. Commercial paper, Article 3, is negotiable instruments. A negotiable instrument is a medium of exchange for money that does not include cash or securities. There's order paper and bearer paper. Order paper is transferred by negotiation, endorsement. Bearer paper is transferred by possession. There's notes and drafts. A note is a two-party instrument with a maker and a payee. A draft is a three-party instrument with a drawer, a drawee/payor, the bank, and then a payee. In a two-party instrument, the maker is primarily liable. In a three-party instrument, the bank, the intermediary, is primarily liable, whereas the drawer will be secondarily liable. In order for negotiable paper to be negotiable, it needs to be a signed, written, unconditional promise to pay a fixed sum of money with or without interest on demand or definitive time to order or bearer with no additional undertakings. The key thing that they like to test is conditionality. If I promise to pay Susie $400 if the Dolphins win the Super Bowl, that's conditional and it will not be a negotiable instrument. Negotiable instruments, remember, they can be transferred: possession for bearer paper, endorsement for order paper. And then there's going to be holder in due course. A holder in due course is just like a bona fide purchaser or a buyer in the ordinary course of business, which is someone who takes the instrument for value in good faith without notice, and they can only be subject to the real defenses, not the personal defenses. So only the fraud in the factum, not fraud in the inducement type defenses. And then negotiable instruments have presentment warranties that the person presenting can get paid, and transfer warranties that when you transfer it, it's an authentic instrument. And then secure transactions, Article 9. Secure transactions applies to collateral, but not property. That's mortgages. And then for fixtures tied to property, you would need a fixture filing. But for Collateral, like tangible collateral. We're thinking consumer goods, farm products, inventory and equipment, or intangibles like accounts receivables or chattel paper or stocks, bonds, right? These could be intangible collaterals. Um, you attach via security agreement, and the security agreement does need to reasonably describe the collateral, whereas you perfect via financing statement, and the financing statement can have more generic terms in what's describing the collateral. If it's perfection of a car, then you actually need to note the interest on the title. So remember, attachment by security agreement, perfection via financing statement, and perfection will determine priority. But just like a PMM in real property, there's what's known as a PMSI in secured transactions. That's when the lender lends money that's used to buy the collateral, and they'll have first or second time first and right priority if they are a perfected PMSI. There's automatic perfection of PMSIs upon attachment in consumer goods and a 20-day grace period for perfection of PMSIs in non-consumer goods like inventory equipment and farm products, right? So as long as you perfect within 20 days after attachment, you'll have super priority for non-consumer goods, and you'll automatically have perfection upon attachment in consumer goods and have priority. There's some things that you can attach and perfect via control or possession, right? You don't always need the security agreement or the financing statement, but that is the most usual way, right? So for secure transactions, remember the types of collateral, inventory, equipment, consumer goods, and farm products. Remember attachment via security agreement, and we need to describe the collateral in the attachment, like sufficiently describe the collateral in the security agreement. Perfection via financing statement, which could be more generic. And then priority is first in time, first in right. Perfected will be unperfected. To perfected, whoever was first in time will win unless it's a PMSI. A PMSI that's properly perfected will always prevail. And then Florida, we do not allow for breaching the peace. So you can try to recover your collateral, but you can't breach the peace. If you need to breach the peace, then you would need to seek a writ of replevin from the sheriff's office. So I know people get really, really scared about secure transactions, commercial paper. Just go over the outlines a little bit, do some practice questions. There's not going to be too many questions. Business entities, if it's tested, will be tested sufficiently. So I would, really go over corporations and partnerships and try to learn as much as possible. And really, with Florida multiple choice, my overall advice to people is down the stretch, definitely do the FBB questions over and over until you get them all right. Do some other questions from, my Q bank and other Q banks to just kind of get some more familiarity and practice. But that's not super, super, super helpful because the questions are going to be significantly different on test day. What is super helpful is going back to the codes, the statutes, the actual black letter law, and just dialing in on cold, hard facts that you can remember, right? Like, because those questions you definitely want to get right. If they say, how many days to file the complaint, and they give you 150, 120, 190, you want to get that 120 and get that point. So that's what I really encourage people as we are getting down to the finish line for Florida multiple choice. Really focus on black letter law, dates, times, and things you really can get right, and going more into the outlines and actual the codes like the Florida rules of civil procedure, the Florida rules of criminal procedure. Go back and read the statutes. I guarantee you'll find that a lot of the concepts that confused you in lecture or in practice questions will become clear when you read the specific text from the statute. So, that's the type of stuff I would do this weekend. Cross my T's, dot my I's, and get ready for battle. I think that the Florida bar exam is extremely passable because of the ability to just pontificate on essays, whereas in the MEE, you have to write exactly an answer on your essays. On Florida, you get an opportunity to have a thorough discussion with the reader and reach for points and get rubric points based on everything you write. I will tell everyone that the Florida multiple choice test is monstrous. It's one of the hardest tests in the universe. But I had a student who did this exact program last time who got an 89 out of 100. I have Marion, one of my instructors, who got a 30 out of 30 on wills. I have Amy, one of my instructors, who I think she got a 164 on the test, and she damn near got perfect scores on Florida multiple choice. Joel, who I've given you his outlines that he created, He got a 26 out of 30 on business endies, which is really impressive because of how difficult that subject is. So, my students have been able to crack the code of the Florida multiple choice, but even if that's not you and you just go in there and do pretty adequately, you'll do fine. There's 30 questions. If you get a 17 out of 30 on all of them, that's a passing score, right? So it's one of those tests where like you don't need to get 28s out of 30s. You just need to get, anything in the 20s, 28, 2 out of 30 would be phenomenal. So go back and try to, memorize the black letter law. And then on test day, there's going to be some really, really tricky questions. Just go with your gut, choose your best answer, and shake it off. I don't think anyone's going to walk out of Florida multiple choice except for Jim Nelson. He felt extremely confident. But most people, they feel a little bit uneasy, and that's just because of the difficulty of the exam. But you don't need a 92% on it. You need more like a 55% on it. So it's a difficult exam, and as long as you do adequate and get more questions right than wrong, you should pass. And even if you have a tough go on Florida multiple choice, the Florida essay section could really carry you. So down the stretch, make sure that you have the rules of law memorized and you're ready to articulate them on test day. And when you get into the testing room and it's time for the Florida essays, you got to hit the ground running. There's no time to freeze up and to stutter. Just really be writing until the wheels fall off, and try to allocate the proper amount of time to each essay, submit 3 well-written, robust answers, and that should carry you. And then for students who are taking the MBE, I'll have plenty of advice for you tomorrow at my class from 11 to 1. So for those of you who I won't have a chance to see or to speak to before Tuesday, I'm wishing you the absolute best. Remember, it's just a test. Don't make a mountain out of a molehill. You go out there and put your best foot forward and things will work out. My grandfather would always say, as long as you take care of the details, everything will work itself out. So right now, spend the time taking care of any details in terms of preparing for executing on the exam and memorizing any things that you might not have down crystal clear. But I have a lot of confidence in all of you. This has definitely been one of my favorite classes of all time. It's been the Sharks, it's blood in the water. Thank you all so much for hanging with me this afternoon. I'm going to stop this recording.